One of my clients called me not too long ago. He was renting an apartment that he thought he had outgrown, and he decided to get a new place. He found a new apartment, paid for it, and started moving his things. But his rent in the old apartment was still running. So, like many people would, he took his time. He moved some things to the new apartment and planned to come back for the rest. And then one day, his phone rang. His landlord had broken into his old apartment, moved his remaining belongings onto the balcony, and changed the locks. When he told me what happened, I totally understood why the landlord was frustrated. The tenant was obviously moving out. The apartment would soon become vacant. The landlord wanted possession of his premises. At first glance, that sounds reasonable, right? Except there's one problem. The law doesn't reward frustration, it only rewards the process. And that is exactly what we're talking about today. Because many tenants don't know their rights, and many landlords don't know where the legal line actually is. Let's start with the question that matters. Can your landlord evict you without informing you? The short answer, no. But the reason for this is where things begin to get interesting. Before we talk about notices and court orders, let me tell you something I've noticed from time to time. The first document I ask for whenever a tenancy dispute lands on my desk is the tenancy agreement. And you will be surprised how many people never actually read theirs. They signed it, filed it away, and only look for it when there's a problem. In fact, not too long ago, I reviewed a tenancy agreement that looked perfectly normal at first glance. It stated clearly that the tenancy was a yearly tenancy intended to run for 2 years. Fair enough. Then I looked at the dates. The commencement date was 19th May 2026. The expiry date was 30th April 2028. And immediately I paused because those dates weren't quite telling the same story as the clause. Now, maybe that's just a drafting mistake. Maybe. But small mistakes in legal documents have a habit of becoming very expensive arguments later. That is why I always tell people this. Don't just sign your tenancy agreement. Get a lawyer to review it for you. Read it, check the dates, check the notice clause, and make sure the document actually says what everyone thinks it says. Because when disputes arise, one of the first places a court will look is the agreement itself. Now let's assume the tenancy agreement is in order. The next question becomes this: how does a landlord lawfully recover possession? The answer is through a process, and this is where many people get into trouble. Before a landlord can recover possession of his premises, he or she must go through these three steps. Step 1: the notice to quit. A landlord must serve a written notice to quit on the tenant before anything else takes place. Under the Recovery of Premises Act in Abuja and the Tenancy Law of Lagos State, for a yearly tenancy, that is generally 6 months. To be sure what is applicable in your jurisdiction, reach out to a lawyer. But before we move on, let me mention something I've come across in practice. I remember reviewing a tenancy agreement some years ago. It was a yearly tenancy, but when I got to the notice clause, the agreement provided for only 3 months' notice. Meanwhile, under the law, a yearly tenancy ordinarily requires 6 months' notice. So the obvious question becomes, which one applies? The 6 months in the law or the 3 months in the agreement? And the answer may surprise you. It is not always the agreement. The law sets a minimum, and no contract, no matter what it says, no matter who signed it, can take away what the law has already guaranteed. A notice clause that gives a tenant less than the law allows is void. The court will not enforce it. So in that case, despite what the agreement said, the 6 months would still apply. This is why reading your tenancy agreement is so important, but also why knowing the law behind the agreement matters just as much. Because sometimes what you signed is not the final word, the law is. Step 2: the 7 days notice. If a tenant remains after the notice to quit expires, the landlord serves a 7 days notice of intention to apply to court. Step 3: the court order. And this is the step many people try to skip. A landlord must apply to a court of competent jurisdiction and obtain an order of possession. Only then can lawful eviction proceed. Notice something about those three steps. At no point does the law say break the lock, move the tenant's belongings, remove the doors, throw their things outside, remove windows. Because the law doesn't reward frustration, it rewards the process. Before you leave, I want you to do one practical thing. If you're a tenant, find your tenancy agreement today, not later. Find it now. Read it. Look at the dates. Look at the notice clause. Look at the duration. And make sure all those provisions make sense together. If you're a landlord, do exactly the same thing. Review the agreement you're currently using. Make sure your dates align. Make sure your clauses are consistent with your intention and with the law. Make sure the document says what you actually intend. Because a well-drafted tenancy agreement prevents disputes. A poorly drafted one creates them. So before we leave today, remember this. A landlord may own the property. A tenant may be in the wrong. But neither of those things allows anyone to ignore the law. Because the law does not reward frustration. We've now talked about what the law requires. But what happens when a landlord ignores the process completely? We'll answer exactly that in part 2. I'm Goga, and I'll see you in the next one.